What if you pass away without a will? So, if you pass away with no will in place, state law fills in the gaps. State law will dictate who gets what. If you haven't clarified it in a will or a trust, it'll dictate who your heirs and beneficiaries are. State law tends to follow kind of what you might expect people to choose. For example, a surviving spouse is the primary heir and then children after that. If there are no spouse or children living, then it goes to your parents if they're living. If not, then it would go to siblings, then nieces and nephews, and it would keep going until someone is available to receive your estate. But it can get a little tricky, especially if you have a blended family, or either you or your surviving spouse have children from a different relationship, because the numbers get a little tricky and they don't just go flat out 100% or in equal shares in that case. So even though Florida law does fill in the gaps to make sure that people who are close to you receive your estate, it might be different from what you would have wanted. And it also doesn't clarify who's in charge of the assets left to a minor or an incapacitated beneficiary. So state law is really just following a family tree, but really doesn't do a whole lot more than that to make sure that those who do receive your estate receive it in a way that you would want them to, or how you would want them to receive it, such as maybe at specific ages or stages. So if you die without a will, although state laws fill in the gaps, it may not be in the way you would want it to go, which is why it's really important to make sure that your plan is laid out in writing ahead of time, so we're not having to rely on state law for you. The state plan also requires that your estate go through probate. So that's another thing to consider.